First of all, I want to welcome everyone for this second edition of the Data Protection Day, which is, as you know, organized by the EDPS, the Privacy Salon from the CPDP conferences and the Council of Europe. Thank you as well for having chosen this panel, this side session, seeing that the competition is quite high on the other panels. But you're not going to be disappointed, I promise you. My name is Romain. I'm a legal officer at the EDPS. And it's my honor to moderate this panel organized by the Privacy Salon, the CPDP conferences. Today we're going to discuss about the true stakes of data protection. What do we mean by that? We all know that data protection is not about privacy. Well, not only about privacy. We all know that it's not only about imbalance of power between controllers and individuals, the right to self-determination, or the impact on our physical or digital selves, like the right not to be discriminated. But then, what is really data protection about? I think in my past years doing data protection, and I've been doing data protection for 20 years, more than 20 years, sometimes it seems that we are forgetting what we are talking about and what we are protecting. During this panel, we would like to go back to the basics and remind ourselves why data protection is so important. What is the objective of data protection law, of a data protection law, and what lies behind the rights that we, lawyers, experts, civil society, private companies, authorities, and DPAs are invited to protect? That's what we are going to discuss today. What are the objectives of data protection laws is one of the main subjects that I would like to address with my panelists today. We are going to explore this question with I think it's 5 brilliant panelists that I'm happy to introduce. If I didn't have any approval to start the introduction, but I would just do so. On my left, you have Evgueni Boev, who is Senior Legal Advisor at the European Court of Human Rights. Gloria González Fuster, Research Professor and Director of the Law, Science and Technology and Society Research Center of the VUB, Brussels University. Max Schrems, Chairperson of NOIB, None of Your Business. Nathalie Larnay, Vice President in Government Affairs and Public Policy at Criteo. And Itxaso Domínguez de Olazábal, can be improved, I think, Policy Advisor at EDRi. So now that you introduce anyone, I just want to make sure that I can start officially. Is it yes, no? It's a quantum answer, it's like between yes and no?
Balance.
It's a balance. Apparently, we have the approval to start. Good. And if you want to know more about the panelists, feel free to read the program. Of course, you will know more about them. First, I would like to have a first question to break the ice that I would like to address to all the panelists that we have here. I remember that a member of the parliament, that I don't remember his name, during the negotiation of the GDPR, replied to the people who said that they did not care about privacy because they didn't have anything to hide. And I remember this guy just answering to these people, guys, if you don't have anything to hide, maybe it's time to get alive. And I really remember this answer as a cool one, which I think is a nice answer to people who are doubting about whether we need data protection or not in the EU. So my first question that I would have to all of you would be in simple words and in a concise manner. How would you explain to a young teenager why we need data protection law? Who would like to start?
Apparently, I would like to start. Thanks so much for being here, and thanks so much for organizing this very much needed and timely discussion. I'm just going to start by saying that this morning I had to step in for a colleague at our hearing at the European Parliament about the impact of social media on young girls' mental health. And actually, I ended up speaking about data protection and how all of these toxic algorithms and all of these very dangerous recommender systems are fed on data that they that has been exploited from us through all of these social media and other interfaces. And children are very much aware that the social media is very much needed for them to harness social skills, to learn new capabilities, to learn new people, to acquire knowledge, but they are also aware of the risks and that social media entails for them in terms of self-harm, in terms of body image. And actually, one of the solutions for them not to be afraid of social media, not to be afraid of how so dangerous social media has become through all of these addictive design, deceptive designs, will be to stop all of these companies from exploiting their data, from stealing their data. And this has to be done through data protection and other complementary privacy or data protection frameworks.
Seems convincing to explain that to a teenager. Who would like to go next to? Sorry, Evgueni or Gloria? Don't.
I love this question. I'm very happy to be here today celebrating data protection, because in this very building, I was here in 2010. I don't know if you remember, in 2010, the European Commission organized a meeting to announce that they were going to revise the data protection directive. There was going to be the data protection reform. And I remember very well that day because I was pregnant and I was announcing to people that I was pregnant and that the data protection directive was going to be reviewed, and I was so excited about this, and people didn't ask me about data protection. I thought, ask me about data protection. And so I was pregnant at the time, and now my son is a teenager. He's 15 years old. He's taller than me, not yet smarter than me, but on his way. And I realized that I don't have to explain to him anymore why this matters. So I've tried many times, and I think he tried to resist. One day he was punished because he was screaming, Facebook is my friend, Facebook. And I said, no, say this again and you will be punished. Facebook is my friend. But now he has learned, he's 15 years old, and he understands very much, and he watches the news, and he sees all these people around, people of power, and he sees what happens with people being all the time on the internet, and the importance of data protection. So I think teenagers, I don't even need to explain this to them anymore.
Thank you, Gloria. Who would like to go next?
Yes, hello.
Evgueni.
Yes, thank you. Hi. Well, I think this question could be framed even in a more general way. Why do we have laws, specifically data protection laws? Of course, normally you would expect, if we're explaining to a teenager, normally you would expect people to act fairly and honestly vis-a-vis each other, and not to abuse positions and not to abuse the possibilities of hurting others. But sometimes they do, and that's why we have laws. So you have to check, keep bad actors in check. And specifically when it comes to data protection, we have all heard of abuses by governments, by private entities, by especially totalitarian governments. We all know the horrific stories that we hear about some countries. Let's not name anyone here, but about mass surveillance and total disregard for individual situations and rights. And that's why we need laws, to keep those in check, because in a democracy, the law is king.
Thank you, Evgueni. Sorry, thank you, Evgueni. Natalie, maybe you want to share, maybe you don't have a teenager, but how would you explain it to?
Yes, thank you. Thank you. Hello, everybody. Thank you, Romain, for inviting me on this great panel. I think what I'm going to say is very close to what Evgueni has just said. Is really about protecting our fundamental rights on the ground and ensuring that data is not used against us. And that we have control over it, and that's why we have obligations of transparency, accountability, and of course, data subject rights.
Thank you, Natalie. Max?
Yeah, well, how should I say it? I think there's, I think everything that we already heard, I could subscribe to. I don't know if the teenager is oftentimes the best question. I just over Christmas had like a longer conversation with the now teenager of my best friend when I was a teenager. And it was amazing because like 17-year-old, and they were like, I know this is fucking with my brain. I know I'm doing crazy stuff because the algorithm is telling me that. They're apparently quite aware. They're not aware of how to stop it. They're like, I can't stop doing it. So it was quite interesting, whereas like a bit like halfway reflected and the other half still in that bubble. So I think oftentimes that's becoming more and more of a reality. What I think is the more important question, at least for us sometimes, is people are aware of this first layer that they see on the screen. But then there's really this big question of what happens behind that. That's oftentimes where data protection comes in, because if that data wouldn't exist, the first layer wouldn't exist. But that's the part where the average person just discontinues because it's too complex. And I think just to add to what was said before is the societal part of this. Like you can yourself disconnect to that and yourself not deal with it, but you, for example, still have an extremely polarized society that you're going to be in no matter what. So I think we also, I mean, we have obviously the GDPR has like this individual rights approach, which we obviously have. But then in addition to that, we also have the societal problems that I think we can hardly ignore anymore by now, where it's hard to kind of do that on, I don't know, for example, a consent basis, because that's individual protection, not like structural protection. So I think there is oftentimes, to go to the topic of the panel, then these results where it goes beyond just GDPR, and GDPR is maybe this horizontal thing that has these consequences that follow.
Thank you very much, and thank you for your concise answer, because we have a lot. I have a lot of questions for you, but I think we're not going to go to the end of the panel with all the questions asked. The second question that I prepared for you, and I think I have to change it a little bit because my question was about your top priorities, but I would ask you a top priority, just to make it clearer. Is it okay? In terms of data protection for you in your daily work, and what would be the top priority in terms of data protection in your organization? Of course, if you mention two, I would not be too upset. Who would like to go first?
I'm happy to start. I'm happy to start, and I'm going to have just one overall priority with several sub-priorities. Is that okay? Of course. So, I mean, well, first of all, I would like to echo what was said this morning about the fact that it's good that we have a few companies invited to this conference, and I'm really proud to be actually representing the only European company. And the only European company that actually is the first private European AI lab headquartered in Paris, with more than 120 engineers working daily on a matter of topics related to our business, which is online advertising, but also related to key issues that we are discussing here today, such as fairness, privacy-enhancing technology, and so on and so forth. So naturally, top priority for us is AI, and as I said, there are different sub-priorities, and as part of this is, of course, how does the GDPR applies to AI, and how do we reconcile the legal complexity between having a regulation on data and a regulation on the algorithm with different approaches, so that we can provide legal certainty and clarity and previsibility to the business teams that are working daily on innovating. And it comes to a second point, which is the guidelines of the EDPB on pseudonymization. And thank you for the EDPB for putting this together. We, as a company, only train our AI model with pseudonymized data, and we will be looking into this very closely. And last but not least, our main priority is, of course, competitivity. Because of the current events globally, we really need to make sure that we have European champions if we want to continue to protect our European fundamental values. I will stop here for now.
Thank you, Nathalie. Who wants to go next? Go ahead, Evgueni.
Hello, thank you. Just very, very briefly. Well, since I come from a court, I think our top priority should be to get it right when we get a case. When we get a case which involves data protection issues, that we don't say anything in the judgment which 10 years later we'll regret.
Yes. So your question is about what should be the priority for my daily work. Data protection is the priority most of the time in my daily work. Yes, so I think I would prefer to tell what should be the priority for other people, because, academics, we talk about other people, we try to do what our daily work, how we can, and I've been thinking about what should be the priority, I believe now, for data protection in community in general, specifically for data protection authorities. We know that they are key in all this, and my message is, please handle the complaints. That should be the priority. Handle all the complaints, handle them now, handle them with due diligence. This should be your priority. If you have free time to think about AI, that's cool, but otherwise, handle the complaints, and because that's now what is really the key gap. Thank you. And it's not even my complaint.
Very nice, thank you.
Yeah, I think just in line with what Gloria said, I think it's for GDPR to be enforced and to be enforced as it should. We are seeing clear deficiencies throughout these last years when it comes to the actual enforcement on GDPR, and now we are not even addressing these insufficiencies. We are being confronted with a shifting of the public debate that speaks about innovation and competitiveness, that is clearly about deregulation and about, not applying GDPR the way it should be applied. Whereas, again, enforcement is not done the way it should. For example, we have a regulation that is now being negotiated, GDPR procedural. Maybe Max wants to tell you much more about that. That is about making sure that these DPAs, as Gloria said, actually handle the cases that they have to handle, the complaints that they have to handle, and that individual complainants and also NGOs, as per Article 80 of GDPR, do not have to be confronted with 5-6 years of torturous procedures that are not getting anywhere, or have their complaints dismissed just because there has been an amicable settlement or a mechanism that has been made up in order not to actually apply the law. So we need to have data protection. With data protection needs to be enforced right and enforced correctly and in a timely and very rigorous manner.
Thank you. I see that enforcement seems to be a priority for the both of you. I guess you have a different idea, Max, obviously. Maybe.
We're stealing our microphones. Being purely an enforcement organization, I'd probably join in what was said before, but I would probably make the connection a bit more, because I think we need to break up this like more or less, one side versus the other and so on. Just to give you a couple of numbers before what I said, I mean, we put out a press release today for Data Protection Day, as you do as a good NGO, and we looked at the EDPB numbers, and if we look at all the complaints only, that's not ex officio procedures, but only the complaints, and then look at how many penalties we have, it's 1.3% of complaints that ever receive a penalty, just to kind of put that a bit in perspective on real numbers. In Austria, we recently made a press release because of Court of Justice ruling where they said, you can't just say you have 2 complaints per month and then you're done, which was one of the craziest arguments I've ever heard. But just to put in perspective, the Austrians, I think, put about 60 decisions per year, 60 penalties per year. I was looking up in the summer, the city of Vienna fined 7,000 owners of e-scooters for wrong parking of e-scooters. 7,000. That we can do. GDPR violations, I think 54 per year in the whole country. Just, it's really amazing if we compare that to other metrics. We have 8 million speeding tickets per year in Austria. And the average car in Austria gets 2 speeding tickets. Just to put all these things in perspective to what we do into the GDPR, and then we really have to wonder what's going on here. If we then ask DPOs, 74% of them said that the average companies have serious privacy violations if you would walk in there tomorrow. So it's also, if you ask the DPO side anonymously, they are like, first number is penalties, publication of decisions, and B2B basically control that they say would get their CEO to comply, their boss, that they tell, please do this, and the boss says no. So that's quite interesting if you look into that. And if you now move it back to what we talked before, why do we do all of this? Now 5 years in, we brought cases about exactly this information, which is based on Article 9 data, which is sensitive political data. And these cases, for example, was rejected with Facebook. That was a case that the DPC didn't investigate. I mean, the EDPB actually pushed back on that for good reasons, but that is exactly the data that is now used for that disinformation. That's the data that is used for what Zuckerberg says, we're not going to go into conspiracy shit and remove it. With that data, you can still spread it like crazy. And so there's the connection of real life consequences with these things not being dealt with. And I think now 4 or 5 years in, we have to wonder, if the consequences aren't coming up. It's a bit like, environmental stuff. If for 5 years you don't do anything, not a big problem, but after 10 years it accumulates in your water, what you put in there. And I think that's a bit where my worry is, that we're continuing on that trend with different narratives.
Thank you. Very interesting. I was just trying to follow my little script, because I had a little script for you guys. And I will have a question for each of you, addressed directly to each of you, but of course I will kindly invite the other panelists to comment on the answer given by the panelists. The first question that I would have, or maybe Itxaso, you wanted to have the first one? No, fine. Sorry, I misunderstood. But Evgueni, I would have a first question for you, so you will be the first one in the line. And it's kind of not provocative, but it may be provocative, but a little bit more controversial question that I would have for you. We hear currently a lot of voices raising the right to conduct a business or the freedom of expression as another fundamental right to be taken into account against the right to privacy or the right to data protection. Do you see here a contradiction or a tension? And how would you see, or how do you think that we can solve this tension?
Well, that's maybe a modern iteration of a very classical question about the conflicts between fundamental rights. Otherwise, that's a very sort of one of the real classics in human rights law specifically. How do you balance one human right against another? Of course, there is tension, but there is no contradiction, I would say. Inevitably, in given situations, you have tensions between fundamental rights. For example, if you defame somebody, that is your freedom of speech against somebody's reputation, somebody's right to private life. That's something which goes back to 200-300 years. Now we have it in the more modern era with data protection. And the way to solve this is through the classic old, in my view, concept of proportionality, that you cannot give automatic precedence and priority to one right or the other. You just look at both and how they interact in the specific situation, and then try to reconcile them as required by the specific situation. And of course, in one set of facts, that could mean you give full priority to one right, because that is what's just and proper in the situation. That's what's proportionate. In another situation, you restrict a little bit one of the rights to protect the other, but not too much. In another situation, you go in the reverse way, etc. And I wouldn't like to comment on any cases before the European Court of Human Rights, because we like not to say anything which might prejudice a pending or an impending case. But an example from another jurisdiction, you are all certainly aware that recently there was this TikTok ban in the United States, which went before their Supreme Court. And that was exactly, on the one hand, you had the right of the company, which nominally at least is a private company, to operate its business. Then there was also, on the same side of the equation, the right to freedom of expression. There was a very strong brief by the American Civil Liberties Union in support of freedom of expression in that case, arguing against the ban of TikTok. And on the other hand, you have all these issues with how TikTok might be abusing data, first to push its algorithm and all the trashy stuff which is coming out from the videos, and also to abuse the data and maybe send it back to the jurisdiction where it would not be properly protected. And well, the Americans, at least at this stage, they opted via legislative measure to restrict one of the rights. And that's an example where you do have a tension, but not necessarily a contradiction. Inevitably, this will arise over and over again. And again, even in this TikTok story, I don't think that the Supreme Court ruling is the end of the matter. There are now some pointers that the whole situation might be revisited. So again, proportionality, that's kind of the key word. It is very vague. When you just say it like this, it means nothing, but in a specific situation, it always leads you to a concrete result, and if properly applied, that should be the just and proper result.
Thank you. As a European lawyer, panelists would, maybe other panelists would like to comment on.
I think I would like to comment on it because, for example, I'm going to be controversial, as you asked us to be. And for example, many of us, I guess, were present in the EDPS stakeholder on pay or okay, on consent or pay models. And I think, one of the arguments that were put forward was you need to apply this proportionality between GDPR, between data protection and freedom of expression, and between freedom to carry out business. And it was very hard to swallow because on the one hand, data protection is clearly violated and in these consent and pay models, but also, all of these social goods that are promised to us via freedom of expression, via innovation, there's no evidence of that. There's evidence of all of the harm that these companies, these platforms are using, all of these that resort to consent or pay, but there's no evidence of the promises that they are using as an argument in order to adopt an unlawful model. And the same with AI. I am really happy that you brought AI to the table. I think, and we all know that AI can be potentially beneficial for society, but nobody has come to the table and has explained why amassing huge amounts of data for the sake of feeding LLMs can be a social good per se, and should be actually be used in order to justify applying GDPR in a less strict manner than it should, through legitimate interest and through not resorting to the criteria of legitimate interest. So I think I really believe in, I'm a lawyer myself, and I really believe in the proportionality between different fundamental rights, but I think somewhat this narrative has been used in order to legitimize, in order to defend not applying the law as it should under other pretenses.
Yeah, I mean, I want to give another perspective, and I'm really happy actually to have learned this morning that the only absolute right under the Charter is the freedom of thought. You know, that gives me...
And torture.
And technically torture, and torture as well. I learned that also through Evgueni, but this morning on the panel, it was said also that freedom of thought is an absolute right, which gives me confidence that I can think differently from the rest of my co-panelists, and maybe also express it as long as I respect freedom of expression limitation. So just to give a different perspective on, you know, as to what is the purpose of AI and how different rights can fit in together, and why we process all this data, and that we, you know, violate rights and things things that you have just been mentioned. I just want to give, of course, the use case of online advertising, and thank you for bringing the pay-or-consent model example, because you really need to understand that actually by using these models, and you mentioned LLM, but I have to say also that, and you know, that we have to be cautious that AI is much more diverse than just LLMs and generative AI. Generative AI is a bit of marketing, but AI has been existing for more than 70 years. Before it was called machine learning, and now we use the term artificial intelligence, but at Criteo we don't do LLMs, we don't do generative AI, we do discriminative AI, which is really to be able to show the right ads at the best time for the best person to really get the best outcomes for the advertisers and the publishers. And why I'm mentioning this is because by enabling this, we actually fund free access to internet. And as a matter of fact, when an advertiser spends 100 euros with Criteo, the publisher gets 60 euro back to be able to fund free access to content, to be able to pay journalists, and to be able actually to fund their business model. So this is where I think online advertising is really a good use case and a good example as to how those actually fundamental rights, which is on the one side right to privacy, but also right to conduct a business, but also right to access information and media plurality, all of these are fundamental of our democracy, fit together.
Thank you. Who wants to answer on that?
There's so much I would want to say. I'll try to keep it with one or two things. First of all, I'm giving 10 euros everybody in the room that doesn't misuse the Article 16 or the freedom to conduct a business anymore. That has a very specific meaning. Look at the case law. It's basically, for example, not a limited number of taxi licenses or of AI licenses, but it's not a freedom to make money. We don't in the EU have a freedom to make money. We have public interest in AI, which I think is actually what the interest here is that competes with the privacy right, is the public interest in having AI trained. That's a different story than a fundamental right to under Article 16. But that being said, moving on to the question of, for example, pay-or-okay, or how we can balance that. I mean, that's even a more interesting situation, because it's not a balancing test. We don't do that under legitimate interest. We do that under consent. And consent basically means giving up your fundamental right, which you can do. I always say you can jump off the bridge, give up your fundamental right to life, so you can also give up your right to privacy, fair enough. The interesting part there is we say that you have to do that freely. You must actually want that. And we know from public studies, actually by the industry largely, that about 3% of people actually want to have online advertisement, give up their privacy for that. 99.9% agree in a pay-or-okay module. So it's a bit like, you know, I joked once, if I go to a bar late night and about 3% of the people actually want to hang out with me and 99.9% end up in my bed, then probably that's not overly consensual. And this is pretty much what we do with pay-or-okay here. And I think that's the first part. And then if the economic argument comes into it, which from a legal perspective doesn't matter, because freedom of consent is not an economic question, but if that argument is made, the really interesting part is that we know in a pay or consent model that they usually overcharge about 100-fold. So we know that the average, I forgot the exact number in Germany, but I think it was like 15 euros per year that you do with online advertisement per user in all of Germany. That's the IB number. Look at the exact one. Maybe it's 20, something in that ballpark. However, one newspaper charges you 100 euro for the consent or pay system. So just accessing one page overcharges you partly tenfold what the whole country is making in online advertisement. So these arguments of, oh, we need to make money, all fair enough, sounds wonderful for a lobby speech. But if you look at the actual numbers, which the IB publishes, you just have to divide it, you realize that they actually don't match. So I think a lot of that needs a bit more maybe digging into than we just had right now. And if you look at the actual statistics and the actual numbers, there's very different outcomes than some of the narratives that are used for that. However, regulators don't look at that much. In all the cases where we put that forward, this evidence is removed from the final decision, interestingly, so we'll see how that plays out.
I'm not sure. We started with proportionality, then we touched many different subjects. And yes, I keep having this example in my head that I know it's a wrong example because I'm going to bring the mood down and I don't want to do this. But yesterday there was two big news on the news. One was the Chinese app, and the other big news was, remember, Auschwitz being liberated years ago. And I'm bringing this, what's the connection? You will say now there is a sort of connection, because all of this is somehow thinking about, is there a proportionality when you get some sort of benefit? Maybe you give your data, but you give some sort of benefit, and isn't that great that you get some sort of benefit? And I have not been doing research specifically about Auschwitz, but I've been doing research about a bit of research about the population register in Amsterdam. So there was a terrorist attack in '43. There was a register of the population in Amsterdam, and so people thought, well, we have to do something against this data processing. They did a terrorist attack. So I did a bit of research about this specific register. And it was in Amsterdam. At some point, the Germans occupied the Netherlands. The first thing they did, they hired a lot of people to work more, to have more people working at the register. And the second thing they did, they put some ads on newspapers saying to families, do you need more food? You want a discount on those essential foods? Come and register and update your data with us, and we will give you this discount. And they collected a lot of data like this. And of course, this is just one boring example from boring academics saying, benefits, of course it's cool to have benefits, but that's typically how, it doesn't mean that because you got some benefits that things cannot get very, very bad, and I hope it will never get that bad, but it is not a reassurance that you will get some benefits. Sometimes it's just even worse, but then you have to think, why are we promising all these kind of things? You're free this, you're free that, and still we have to be careful. Is this now being proportionate? Is this now, are we doing the right balance? So sorry for bringing the mood down. Thank you.
Gloria. I will go to the next question that I prepared, and I must say that just for the sake of respect for the panelists, all these questions were not even prepared and not discussed before, so I'm just shooting the question without the panelists having the occasion to read them before. So I want to thank you for that, but it's something that you asked as well, and they all agree, they were all consented, the consent was free. And the next question is for Itxaso. In your view, should data protection framework evolve to include a broader ethical dimension addressing issues like surveillance capitalism and manipulative design practices, or is it enough what we have now in Europe with the Convention 108 plus and GDPR, or do you think we should evolve to a more ethical approach, in your opinion?
I think we have already touched on what could be my potential answer to that. I think we have already explained or mentioned some of the harms that can be caused by not respecting the data protection framework. We have spoken about children's or teenagers' harms across social media and other interfaces. We have spoken about the dangers of online advertising, even if there are apparently benefits. I think we are all aware of the dangers when it comes to AI, which again, it's fed on data, depending on the kind of machine learning. It's different amounts of data and different sources of data, but there's data in there, and most of the time it's going to be personal data. Pseudonymized is still personal data, but we can discuss that afterwards. And all of it leads to, and AI leads to discriminatory. There's so many studies about the discriminatory impact of AI against mainly vulnerable communities. So I think the ethical dimension is there. Maybe the question is if data protection is not applied as it should, and we already have mentioned and touched upon the issue of insufficient enforcement, maybe we should advocate for other laws that are going to do the job for GDPR, because GDPR is not sufficiently applied, and I think there's a consensus about that. Even if GDPR procedural passes, I think there's still going to be this deficient approach to GDPR enforcement, and this is why, for example, we have the DFA, right? The DFA, the Digital Fairness Act, that people...
Not yet.
We have that on the cards, of course. I mean, and that even though many people shy away from adopting a data protection perspective to DFA, I think I personally believe, and I think this is something that many of the members of EDRi share. We cannot speak about vulnerabilities across social media. We cannot, and other interfaces. We cannot speak about addictive design. We cannot speak about deceptive design or dark patterns without speaking about tracking, right? And tracking at the end of the day is how data is collected and how data is obtained, right? And we have seen the disastrous impact of cookies, and I think this was another question, and how consent is taken from, how consent is taken from users not respecting the criteria for consent. So I think the ethical dimension is that, and I think we are seeing, just as Max mentioned, with this information, we are seeing the disastrous impact on the consequences of how this data that has been unlawfully collected for years is having on our communities and our democratic societies. Something that I was thinking when I read the questions that you sent to us, that are not just that questions, but were in the similar vein, was a case that was adopted recently by the Italian Data Protection Authority it was a huge fan against Globo. And it was about the data protection of the rights, but it was about the workers' rights and how AI had been used in order to discriminate the rights of these workers in order to which places they were sent, which time they were assigned with the platform. So again, data protection is not just for what we call data protection, is for an array of fundamental rights, and it has to do with so many aspects that are essential to our democracy, to our rule of law, to our justice and dignity for all aspects of society, individual and collective, that I think this ethical dimension that you chose to frame it that way is inevitably linked to that, and it has to do with commercial surveillance. It's true that it also has to do with state surveillance, but state surveillance was for another panel, so I'm not going to mention that, but there's also an overlap between state and commercial surveillance that we also need to address at some point, and how law enforcement authorities access the data that has been collected and sometimes retained by private companies. But of course, I don't think any of us that think about GDPR, I think about data protection as a fundamental right, and that as a fundamental right that is deeply interlinked with other fundamental rights, think about GDPR or think about the data protection framework without thinking about this ethical aspect. The only ones that don't do that is the ones that only think about compliance and just this checklist approach to GDPR and to data protection that we need to get rid of at some point.
Thank you. For time management, maybe I would just jump directly to the next question, if I may. Natalie, because it would be for you.
Sure. I need to respond.
Yeah, you need to, but you can also keep silent.
No, I'm not going to keep silent.
In a world increasingly skeptical about tracking technologies. You can't hear me. Yeah? In a world increasingly skeptical of tracking technologies, how can companies balance innovation, transparency, and user trust without compromising compliance, in your opinion? And of course, I would love to hear as well about your take about the ethical dimension, because I know that at Criteo, you have some, if I remember well, right?
I will talk about this, but maybe before, I just want to say that I don't think that we are on the right path here, because I don't think we should constantly oppose data protection and innovation. I mean, if we don't start thinking that the two can work together, I think we're in a bad shape, right? With what's cooking ahead of us, we need to believe that there are technical solutions that enable us actually to effectively protect data protection on the ground whether it is through pseudonymized data, whether it is through privacy-enhancing technology, whether it is for multi-party computing and or federated learning and all those, terms that we hear about constantly. So that means that we need also to empower innovation in these areas within European companies, right? So I think this is really key for us if we want to build the data strategy and the data union that is actually on the European Commission agenda. So we talk a lot about enforcement. Enforcement is important, but let's not forget also about the political agenda and what the Commission and the co-legislator are aiming to achieve to really make us in shape to deal with what's coming ahead of us. So now that I've said this, I will answer your question. Just want to clarify, of course, also that Criteo is an online advertising company, but we don't do political ads, right? So we are very different from some other companies which names have already been pronounced here. And basically what we do is we advertise for yogurt and shoes, right? And we have very stringent advertising guidelines, many things we refuse to do, and we actually try to anticipate things before they become mandatory on us. And so here's how I come to your question on ethics. So we have a product ethics committee where we meet regularly with different key stakeholder from the company, business, legal, AI lab, R&D, product, and so on and so forth, to try to really look at what's coming up in front of us. And as a matter of fact, we have, for a very long time, decided to stop doing any type of profiling on the basis of sensitive personal data and children's personal data. Well, you can say, well, now it's prohibited, right? But this is what we were able to do because we have this approach of thinking through ethical issues before they become relevant. So that's what I can tell you about this. I mean, I would love also to speak about all the things we do around research and also looking at the risk of discrimination and the risk of perpetuation of bias in online advertising. So we have a very successful woman in our AI lab, and I mentioned her because she was selected, her paper was selected at the prestigious AI conference in EDRi. And she's really working hard on making some research in order to avoid that when you go online and you receive a job advertising, that when you're a woman, you only get a job for a secretary, a job advertising, right? I'm talking about job offer, I'm talking about advertisement. And when you're a man, well, you get only offers for CEOs, right? And so really her work is to try to find a way, and it's not easy, because in order to work into this, you actually need to have access to the protected attribute, which is the sensitive data itself, which we don't have access to because we only have pseudonymized data. So she's really working really hard to try to solve this dilemma while protecting at the same time personal data, using pseudonymized data, and ensuring non-bias in algorithm. So this was my answer.
No, very nice answer. Thank you very much, Natalie. It's very interesting to hear a perspective which is including the ethical aspect as well of data protection. I don't know whether any other panelists would like to react on this. Of course. Maybe shortly because we have...
2 seconds, but I think maybe you misinterpreted me and maybe I didn't express myself correctly, but I think I'm not against innovation. I'm not against competitiveness, and I think I can speak on behalf of the digital rights community. I think this is a false paradigm that has been created, that imposed on us. We need regulation in order to make sure that the law is applied and that is applied correctly and the fundamental rights are protected. And if innovation comes in and help us, as you said, protect and guarantee that this law is applied, perfect. And actually, this is something that we had been advocating. GDPR was an opportunity for European companies, as you say, to actually create, to actually design products that would not just enhance privacy, but guarantee privacy. The problem is that and we have technicians in our network, that the mechanisms that we have nowadays to allegedly protect privacy and personal data when it comes to AI and when it comes to other instances, they are not enough in order to anonymize and successfully anonymize the data. And we've seen that, and this is one of the discussions that we had with the EDPB opinion on AI training, or they turn the database into something that is actually impossible to use. So again, all for innovation, and if it comes from Europe, digital sovereignty is also something that we are aligned with. But I think it's unfair to say that all of the people who speak about data protection as a fundamental right and data protection as a very basic fundamental right that is attached to other fundamental rights are opposed to innovation, are opposed to competitiveness, and don't want and don't understand European economy and the agenda of the European Commission. What we are warning is against an agenda that is more about deregulation than about actually respecting and protecting fundamental rights for all of us, but also for especially for the most vulnerable communities.
That's a question that I had for you, especially Max, and maybe I'm not neutral because, as you may know, I was working for Noibus for almost 4 years. So we heard, and I heard personally recently, that sometimes enforcement was just made just for the sake of enforcement, and it was enough. Enforcing was not the ultimate goal, and there was not another goal behind enforcement or complaints or actions for GDPR or even digital regulation violation. What is your take on this? Even if I have a little bit of an idea of course, your opinion. Thanks.
I'll add quickly on the two questions there were before first. And so first of all, I think the ethics and law question we also have to take from another perspective. What we see is, to a certain extent, also a very strong politicization of the data protection authorities. In both directions, absolutely. And what we really worry about is the quality of some of the decision-making and the separation of ethics and law. I have my ethics at night, and probably on this panel right now, but as a lawyer, I have a different head on and have to decide according to the law. And I think especially in the data protection bubble, these two things are very much conflated oftentimes. Things we know are decided one or the other way for political reasons, for whatever reasons. And that is something that on both ends, like we see stuff that just goes way too far. I see data protection authorities doing stuff where like the law does not say that, but I know you have a political agenda to do this here, so suddenly it goes somewhere. And other things, not really. So I think on the ethics and law question, we also have to, think about that separation of what is law and what is ethics, and that's not the same thing. So I think that's just because it triggered me before on that question. On the second part on, solving things properly, the AI conundrum is a perfect example. We ourselves are now using some AI tools for our work, which we're just getting an AI server, and I put it together over Christmas. So no like anti-AI view here, but we're very cautious about what we use, how we use it, and it was really hard to find a compliant product. So for example, when we looked at the AI training discussion, we heard all the stuff about privacy enhancing technologies. But when we asked the lobbyists, at least in my group at the EDPB working group on that, there was not a single privacy enhancing technology that actually was proposed of how to do that on the ground. So we were like, how about data cleaning? If we, for example, pseudonymize the data first, that's great, let's try that. But there was very little coming. So it was more of a pushback than really trying to go this one level deeper of how do we really do this? And I think there is a lot more also innovation to be done that gets us there where it's compliant, it works, it is European, and you have all these elements together. It's more of right now we have these like back and forth instead of going one level deeper and saying how do we actually fix the problem below. And I think that is a bit where we want to go back. Last bit on the enforcement for the sake of enforcement. We get, I think, 20, 30 emails per day of people that are totally pissed about something that happened in their life. And 10% of them probably conspiracy theorists that think something has to do with what happened in their life, but the other 20 real things. And there are a lot of these harms. I think the bigger problem is oftentimes that people cannot connect that harm with the privacy implementation background because they don't know how the system works and why that happened to them. Best example, we're now looking into, for example, credit ranking agencies. And sometimes the score is just wrong and people are still getting their credit, but they suddenly pay 5% more on their mortgage, or 0.5%, sorry, on their mortgage. But over 10 years, that's 50, 100,000 of euros that you pay too much because the score is wrong. They don't realize that because they still get the credit. and they get the same higher credit with all the banks because all the banks use the same score in the background. And that is real harms that we see in daily life, and I could go on with 100 others. And I think that's not the enforcement for the sake of enforcement. Best example where people hated us to go after the cookie banners because they were obnoxious. This is the one thing that we did ever in Neub's history where we got hundreds of emails from people like, thank you, finally someone is doing something against the shit cookie banners that are so obnoxious. So that is real people that have every day they're annoyed by this stuff. And best example of enforcement, to do a positive example last, the CNIL did a wonderful approach to the cookie banner. They had a deadline, said by this date, we're going to have these requirements for cookie banners in France. And we happened to scan cookie banners 5,000 a week before and a week thereafter for other reasons. In that week, the non-compliance in France went down drastically, just by the announcement we're going to do something and clear rules of how they're going to be set up. Suddenly, half of France was able to have a proper cookie banner overnight. And I think that is where people are then actually happy and feel like the regulator did something. It didn't cost much. They brought 20 cases in the end. But they had this general deterrence, this general feeling of there's going to be a consequence of a real thing that people are annoyed about, and you have a consequence that everybody's happy with. And I think that is how I see enforcement, not as like, oh, we found a violation. That's in practice the biggest problem we have. We look at a company and you find 20 violations, and I have to tell my staff, please pick one, not all the 20, just one. What's the most important? It's not a hard thing to find violations. It's really interesting for us to what has impact on society. So we, for example, have a grid of which case goes ahead or not based on impact on society and how many people are affected and so on. So I think that is what enforcement should do if it's well done. And we see examples of how that's well done. We unfortunately see a lot of the opposite as well, but progress, we're moving there.
Thank you very much, Max. And I will move forward directly to the last question that I had for Gloria, because apparently I just received a message that we have to end the panel at 1:15, even if you started a little bit later. So I would like to have at least 5 minutes for the audience to ask any question. And Gloria, my question for you is the following. We hear a lot of criticism that data protection would work in a sort of isolation. Do you agree with that? And how do you think that we should make this data protection framework work with the other digital legislation, especially the DMA, the DSA, the AI Act? And we don't have time to name all of them, of course. And how do you see things interacting in practice or in theory?
Thank you very much. I will also first reply to the previous question briefly. This idea that indeed, there is a problem if you only try to enforce strictly data protection cases. And what's funny is that there's also the other argument saying, when somebody is complaining or they are trying to use their rights and they have a sort of real problem because they fell down on the supermarket or they have a problem with their boss or whatever, then that's also a problem because, actually they are trying to use their data protection rights, but it's not a data protection issue, it's another issue. So then don't use data protection. So then you don't know. If it's only data protection, you cannot use it. If it's other purpose, you cannot use it. Then it's very difficult to know where can you actually use data protection. People will be happy that you use it. That's a difficult issue.
Usually hard.
Yes, so I think that's the problem. About the question about data protection and the broader digital landscape of so many things that we have, I see some people that have survived a training that I give about how to make sense of everything, because it's not easy to make sense of everything of the GDPR inside everything. After thinking a lot about this, I've tried to come to the resolution to think there are many challenges, there are many difficulties, but we cannot only think reactively, defensively, trying to protect the GDPR in front of all this, but we have to see the opportunities and how, for instance, sometimes the GDPR can be enforced beyond the GDPR, the case of profiling and the DSA actually having sort of enforcement of the GDPR that the GDPR was only dreaming of. Now it's there under the DSA, and we have to be proud of this, and I think just say, it's the GDPR, and we can believe in this. There are also some opportunities that are less clear that I think we still should try to hijack some elements in other instruments. My favorite example is the Data Governance Act. You didn't even ask how many people have read twice the Data Governance Act. Somebody was talking about laws being badly written, the Data Governance Act, for instance. But there are some elements in the Data Governance Act that actually, I think, could be used in favor of the GDPR. There are these data intermediation services that are created. Some of them can be created to help people exercise the GDPR rights. They don't do this to actually help people exercise the GDPR rights so they will have better protection. They do this because they say maybe with this they get more data and they can share more data and this is what we want. But they have done this. They have said now it is fine to get together to actually go and reach out to people so you can encourage them to use their GDPR rights. You can possibly use new technologies, automate somehow these kind of things. All this is sort of cool in the Data Governance Act. It is a scene in the GDPR for data protection authorities. Ooh, people getting synchronized, automating these requests. They get very nervous if you think that actually somebody could help you exercising this very personal right. So I think we could say, well, the political agenda, there are some trends that maybe were not there to help data protection, but we can still be a bit smarter and try to help this, and not just be complaining that it's difficult to see how some things connect with each other. I really love questions from the audience, so I will happy give away my minutes.
Thank you so much. And I think we don't have time for the question, the last question that I have for all of you, and I'm a little bit sad because I asked ChatGPT to have a question for the panelists, and I want to mention the question, but we won't have the answer. That's frustrating, but I want, because it was a good one. ChatGPT just asked ChatGPT, can you please, propose a question for the panelists? To ask to the panelists, yeah. Yeah, that's what I did, yeah. No, because the other question I prepared it myself, and it's like a little joke, so it's just so. But thank you for ruining the joke. So the question that I had from ChatGPT, we're not going to have an answer, and again, it's just a little joke, was if there was one thing that you would change in the data protection framework, what would it be? And I think it was not a bad question, actually. I don't know what you think. So that's what I got from ChatGPT. But we're not going to have the answer for this, sorry?
Maybe
but you can ask it. We can take over the question of ChatGPT. So I guess we have time. We have like 6 minutes. I guess we have time for 2 questions in the audience, and we'll see whether we have time for a third one. And I see that maybe online we have also a question, but I would just maybe ask anyone in the audience, maybe Mr.
Yep, thank you. So my name is Robin. I work for FEDMA, the Federation of European Data and Marketing. I just wanted to follow up on a point from the MEP on this morning's panel, that said we need deregulation and simplification of laws and rules. Obviously, it was put in context, but I was wondering what the panelists thought about that specifically, because on the point of enforcement for the sake of enforcement, the European institutions are looking more and more at putting more regulations in place, but there's also a parallel path, which is self-regulation, which is put in place under the GDPR with codes of conduct, which is there, but in reality is nowhere because no code of conduct has, or very few have been actually been approved under the GDPR. Other acts also put in place codes of conduct or certification or other levels of self-regulation. I just wanted to know what the views were on those. Thank you.
The other question, sorry.
Works? Yeah. I liked a lot Giancarlo Margere from Leiden University. I liked a lot the points on dependency and vulnerability for, in particular, social media. But I wanted to ask all of you, or someone among you, what's the first action, the first thing that we can enforce to do that? For example, Article 25 of the DSA about dark patterns, fairness in the GDPR. What's the thing that you think we should push on to fight the digital dependency problem? Impact assessment?
For the first question, maybe to Natalie.
Yeah, because this question enables me also to answer the ChatGPT question and to respond on, is it enforcement for the sake of enforcement? So I think that one of the really missed opportunity of the GDPR is the fact that we've had very few, sometimes no at all, codes of conduct or certifications, which is a big problem, right? Because as companies, especially when the law is unclear, so there are things in the GDPR that are really clear. You cannot argue, you have to do it. But some other provisions are not that clear. And as I'm a lawyer myself, and I can tell you that it's not that easy. And it's a big piece of law. So I think that it would help also tremendously companies if there was more of the constructive engagement way before we get to the enforcement stage, so that we can somehow agree as to what is required from the GDPR in this specific instance, in this specific industry, in this specific use case, and how we assess risk. We haven't talked about risk assessment, right, on this panel, but there's definitely a risk assessment to be made as to how those provisions of the GDPR are being interpreted. And we've missed this opportunity of alignment ahead of all the enforcement through these codes of conduct. So if I had one thing to modify in the GDPR as it currently stands, it would be to put the obligation on data protection authorities to set up those codes of conduct, to set up those certifications, to come up with frameworks that enable companies to know what is anonymized data, what is pseudonymized data, and finally also have the obligation to set up regulatory sandboxes so that also we can test what we are doing, how we are innovating with data.
Thank you, Max.
I was just thinking, I think the first time I was in a Brussels meeting like this, it was 12 years ago or something, and some of the talking points do not change. So it's quite interesting because back then when GDPR was negotiated, the industry constantly lobbied for flexibility of the law, which meant exactly these unclear provisions. Now where we have unclear provisions, everybody is unhappy about the unclear provisions. Pick a road, pick a lane. And either we have strict law that clearly says yes or no. If it then says no, then we're like, oh, it says no, we want to have a flexible rule. and then if there's a flexible rule, then we have a problem of how to apply it. Both cannot be true at the same time. And I'm a bit, it's very repetitive to hear that. And the same thing is true for the codes of conduct. We have them in Austria, actually. And one of my colleagues used to be in one of the code of conduct rules for a business before. It's kids in the candy store. It's people self-regulating. Is literally they were trying to squeeze things in, hoping that the regulator is not going to realize that they just add two things that are definitely not legal. It would work if everybody's adult in the room and if everybody's reasonable and so on. But the reality is there's then a person that has a very strong interest for one outcome, and it's not that reasonable approach that we have. I would be more than happy if we would do that if it would work. We just see in practice these situations. Last but not least, on the question of deregulation and quality, I think one big question we all have to ask in Brussels is quality of the law in general. I mean, I'm just now kind of crying over the procedure regulation because so much of it is so crazy. But overall, we really have to look at how these laws go together. And I think I know GDPR quite well, but with all the data acts we talked about today, I don't have any clue how all of this works together anymore. And that is definitely a problem where we need to see how can we get higher principles that are repetitive, that we know from different parts. Because as a compliance officer in a normal company, I would die right now. I'm lucky that we are confined to GDPR as one thing and don't have to deal with the rest. And we have to go exactly into that of how can we, really make law that is readable, that the average company can follow anymore. That's a big topic that we definitely have to look into. But that may require stricter rules too that are then not that flexible.
Maybe Gloria, maybe Evgueni, you want to add something as well because we didn't hear that. But Gloria, maybe Gloria wanted to.
So to answer your friend, one thing that you could change easily at the GDPR and then help vulnerable people because who are vulnerable people? Children. Remember, just this Article 8 decides something. Decide when are you able to consent, when you're too young to consent. That was so easy to just decide one age and stick to that, and we will understand how to apply this. So things are complicated because there's the GDPR and all these things, but remember the GDPR is complicated because also of the fact that it doesn't harmonize when it should it could easily harmonize. I don't know where we're going.
Just a brief remark. I mean, in my impression, EU law has grown immensely complicated over time. When you compare, for example, the European Convention, the convention that my court enforces, which is, 10 pages, to the GDPR, which is how many pages printed in the official journal, and the two
articles, yeah.
and the two accompanying directives, the one which applies to the law enforcement directive and the one which applies to EU institutions. Generally, that's a very difficult set of rules to apply, in my view, and kind of part of the reason is that it's just too complicated.
forgot on the second question was there, sorry, because I didn't answer that and forgot it. One short thing, I think what's really interesting and what we could use much more for some of these ethical problems is the word fairness, Article 5.1. And we use that, 5.1a, and we use that, for example, in consumer rights all the time. Unfair Terms Directive, since 1993, every court's used that for unfair terms and conditions. We all know these, crazy stuff that no one reads. Very similar to the GDPR. And for example, some of these things, for example, dark patterns, if the DPAs would have a bit of a progressive way of applying that, it's very simple to say hiding the button on the 5th layer is not overly fair. That is stuff where there is some room to also look into a bit more. So I think some of the dark patterns issues, etc., that's just part of your question, but there is some room for the GDPR in a very flexible term that could be used here.
Yeah, just going beyond, because I already said that I think DFA might be used, the future DFA might be used in order to cover for some of the insufficiencies of GDPR enforcement, not GDPR per se, because as Mark said, some of the articles of GDPR could be used in order to at least try to fight against addictive designs. But if you ask me, and if we are on a wish list basis, that will be ban tracking. And if we cannot ban tracking, automatic consent design, so something in order to allow that consent exists, and that people want their data to be tracked, their data to be collected, they have to say so explicitly, because otherwise we know what's going to happen, right? And just also to be controversial, if I could change something in GDPR besides what was already mentioned, and I think this goes in line with the debate that is nowadays happening in Brussels, but as Max said, this is not anything new, is that we agree that maybe SMEs, when it comes to reporting obligations, I hate using the word red tape, but the burden on SMEs is too high when it comes to reporting obligations. So yes, as long as this is not used as an excuse to reopen GDPR and let go of everything that was great to achieve some years ago and that so many of you participated in, I think this is something that we can discuss. But again, not to be used as an excuse to allow for these platforms and these companies to keep doing what they already do in violation of GDPR, not just in purely fake compliance of GDPR.
Itxaso, and I'm afraid that we have to close the session now, and I want to thank you all panelists for joining this interesting session. I hope that you are as happy as I was having all these panelists, that I think we can thank.